see Mr. Davis. Where are there you are. You ready to proceed?
I am, Your Honor.
All right, you may do so.
Your Honor, may I approach?
You may.
Ms. Bright, did you meet with the attorneys for the county to prepare for your testimony today?
I have had several telephone calls with them, and I think I met with them one day last week before my deposition.
And how many telephone calls have you had since your deposition?
2, and there may have been an email message or 2 just telling me when to be available.
And how long did those telephone conversations last?
Relatively short. I think the longest one was probably 40 minutes.
Did you discuss your testimony today?
We discussed the facts as I know them.
Mr. Bright, you referenced on direct examination an instance when you previously represented Anderson County. Do you remember that?
Yes, I did.
One of those cases was the Jackie Hunter case, wasn't it?
Yes, I did.
Jackie Hunter case was a case that went to trial, right?
Yes, I did.
Jackie Hunter case was a case where you gave advice to the county that they had a really great defense in the Jackie Hunter case, right?
I'm sure we did.
You went to trial,
Correct.
you lost.
I think we did.
You lost a several $100,000 verdict.
I believe so.
The county paid for all your attorney's fees and the judgment, right?
Yes.
Many of the council members who were on the county council in 2008 were on county council when you represented them in the Jackie Hunter case. Was that?
I don't know.
Larry Greer was on it?
I don't know.
Larry Greer, he was on the personnel committee?
Yes, it was.
Now, you told the county in this case they had a good defense too, right?
I don't think I was discussing with them a defense. I told them I did not think that the contract was enforceable.
And you cited a long history of
Yes.
South Carolina precedent.
There are very old cases on this point,
Long history.
but they go back a long ways.
Newman versus McCulloch. That's the Seminole case, right?
I don't remember what the Seminole case is.
Cowart v. Ford, that's the next one, right?
That's one I remember.
After Cowart v. Ford, there was the case down in Beaufort, Jasper.
I remember a Beaufort County case, yes.
During your deposition, I asked you what the exception was to that rule. Remember that?
I think that's how you characterized it, yes.
And you told me you didn't know what the exception is.
I think my answer to you was, I'm not sure that I'd call it an exception. I remember discussing with county council that there was something in the enabling legislation that would allow, under certain circumstances, for the county to enter into a contract for a term of years.
And in fact, in the decision of Cowart v. Ford, one of the things that they said was if there is a specific enabling statute that prescribes legislative authority with respect to a term of contract, you can do it, right?
I'm not here to interpret the law as the Supreme Court interprets it. I'm here to tell you what my conclusions were based on the law as it was presented to me. The facts as they were presented.
You're only here to testify that you provided advice that the contract was unenforceable.
No, I didn't provide advice that it was unenforceable. I said I had strong questions about the enforceability of the contract, and I still maintain it today.
Well, now, Mr. Bright, out of fairness to me, on direct examination, you got up and you suggested that you told them that this was an unenforceable contract, right?
I didn't. You didn't listen to me.
Okay.
I told them that I had a real strong concern about the enforceability of the contract. If you haven't read the record back, I think you can see that that's exactly what I said.
All right, well, let me ask you about your real strong concern. In relation to forming that real strong concern, Mr. Bright, did you take into consideration the exception that was outlined in the case of Coward v. Ford?
Again, you characterized it as an exception. I remember that there's something in the enabling legislation that said that there is a possibility that a contract for a term of years might be something that is outside of that general proposition. But I also believe that there's case law that talks about the fact that those can be reconciled.
Can you turn to defense exhibit number 35?
I assume it's in this booklet.
Yes.
All right, I've got it.
And all I'd like to know is, by scanning this decision, does this look like an opinion that you would have had in your file and how you would have marked it up?
Yes, it is. It's the Coward decision. Yeah.
Can you turn to defense exhibit 36, which should be right after that?
I've got it.
And this is part of the enabling legislation that relates to the employment and qualifications of an administrator, is it not?
I believe it is.
And it reflects South Carolina Code 4-9-620.
Yes, sir.
And this is how you would mark up that statute as it appeared in your file.
Again, it looks like this is the way I would have highlighted something as I read through it.
Man, sorry to flip around on you, but you're a little bit more versatile, a witness for exhibit. So you could look at defense exhibit 16, which should be the very first exhibit.
Yes, I've got it.
Defense exhibit 16 is an outline, or more correctly, a timeline of events during your representation, is it not?
Yes, it is.
You wrote this document?
Yes, I did.
You're sent it to the Anderson County Council.
I believe we did, yes.
Now, I'm kind of interested in something, Mr. Brown. If you had any inkling, that there was fraudulent conduct going on with respect to Mr. Preston's severance agreement, would you have pushed forward with representation, sir?
Judge. I'm not sure what you're asking.
If during your representation you learned facts that caused you to believe that the execution of the severance agreement was in some way fraudulent, would you have persisted in representation?
I doubt that I would have, no.
You doubt, or you absolutely would not?
I'm sure that in any situation where there's a possibility that someone has committed fraud, I will not say categorically one way or the other that I'm going to pass judgment on that on a hypothetical that you present me. I can tell you this, I have been in the courtroom before where a witness has testified falsely and has committed perjury. And as a result of that, I took my responsibility and oath that I took 31 years ago, and that you've taken the same one. And I took it very seriously. I took it to the Supreme Court, I took it to the Court of Appeals, I took it to the client, and we exposed that that's what was going on. There was false testimony in a trial. And so if you're asking me whether I would have the integrity to report something that was fraudulent, yes, sir, I would.
Mr. Bright, I have no idea what you're talking about. What I was trying to ascertain was if during this process, the contract negotiation, you learned that it was somehow a fraudulent deed, that it was a put-up job, a sham, as the county's alleging. you would have quit, right? You wouldn't have participated.
I would have explored the issue as I just explained the way I've handled it before, and I would have done the appropriate thing that my oath requires me to do, and that the disciplinary rules that you and I are under would require me to do.
You wouldn't have participated in what you perceived as a potential fraud.
Absolutely not.
Absolutely. And in this case, that didn't happen, right?
What case? You mean, did anybody tell me that?
You were representing the county in relation to Joey Preston's 7th Street. You didn't throw up a flag and say, whoa, whoa, I'm out of this. I'm not going to represent the county in relation to this deal if there's something wrong. That never happened, right?
And what are you talking about? Are you talking about fraud or something that's wrong?
Fraud.
Which fraud? No one expressed anything that suggested fraud to me.
Mr. Bright, on direct examination, you testified about how you informed the personnel committee about a potential downside risk of about $2 million. Remember that?
Again, I think what I should have said is it wouldn't have surprised me that I used an analysis that may have suggested $2 million. I don't remember saying that, but that would not have surprised me. I would have outlined for them what that risk was.
Because I asked you about that just about a week and a half ago, right?
I believe so.
And at that time, you told me you didn't really remember exactly, but it didn't surprise you.
That's right.
Can you turn for me to Plaintiff's Exhibit 3? On direct examination, you were asked questions about how the anticipatory breach or constructive discharge would occur until January 1st of 2009. Do you remember that?
I don't think I said January 1st, 2009. I think we talked about anticipatory breach and that sort of thing. Yes, I remember that.
Do you remember the whole line of questioning about the new council coming in? And
Correct.
Those are the ones that they were really concerned about. It was in the future. Do you remember that?
Yes.
And the new council came in January of 2009, right?
Okay.
About halfway down, the middle of paragraph, or Plaintiff's Exhibit 3, paragraph in the main body, there's a sentence that states, and I quote, certain council members have hindered Mr. Preston's ability to perform his duties as county administrator for at least 7 years now. Those attempts have, thus far, been most unfortunate for people of Anderson County, end quote. Right?
Yes, you read that correctly.
Those aren't attempts to hinder Mr. Preston that are occurring in the future, right?
This sentence doesn't reflect that, no.
And in that exact letter, they're referencing attempts to hinder Mr. Preston's ability to do his job now and in the past.
That's the language that's used in this letter.
It's true, is it not, that you didn't conduct a factual investigation into the validity of Mr. Preston's claims?
What were his claims? Tell me what claims you're talking about, and I'll try to answer that as best I can.
Okay, well, he had claims, remember, for anticipatory breach.
Yes,
He had claims for constructive discharge.
yes,
And then we looked at a letter from October 23rd, 2008 that reflected potential tort claims.
correct.
It's true, is it not, that you didn't conduct an investigation into the facts supporting those claims?
I did not go out and try and interview individuals to find out whether or not There were tort claims that existed. Rob Hoskins didn't share any of those with me specifically. So no, I didn't conduct an independent investigation of those things. That wasn't what I was asked to do.
In fact, when I asked you this a week and a half ago, your answer was none whatsoever. Was it not?
That's exactly right. That's what I'm telling you today.
Can you turn to Defense Exhibit 17, please? The first question I have, that's your handwriting, right?
Yes, it is.
Those are your notes.
Yes, they are.
Those are notes that you take either contemporaneously when you're on the phone with someone, or
Correct.
when you're meeting with them.
Correct.
You don't intentionally put incorrect facts in your notes, right?
I put information in my notes that people are informing me of. So whether they're accurate or not, I don't know. I'm putting down what people are telling me.
Your intent is to capture what they're telling you
Yes.
accurately and correctly.
Yes.
In Defense Exhibit 17, do you see in the upper left-hand corner, it says 5 for Joey, 2 against Joey?
Yes.
And this memorandum was something that you wrote when I don't have any video. You can read the lights on. This was a memorandum that you wrote right after you were first retained, correct?
It reflects my notes the very moment that we were retained. Now, whether or not this was Buddy Daniel, my partner, who was sharing this with me, or whether it was Mr. Thompson over the phone, I don't remember that. But I do remember this was the first note that I made of any information that I had.
And down in the middle of the page, it says, and I quote, WAIM-AM, 1230, Rick Driver, rumor, arrow, second set of books, end quote.
Yes.
Right? And someone was telling you at that point in time that this radio station, WAIM, was reporting a rumor about Mr. Preston.
Yeah, I believe that's what it was, yes.
And the rumor apparently was that there was some sort of second set of books.
Yes.
At some point, Mr. Bright, did you become aware that Mr. Preston had sued in his official capacity to sitting county council members?
Someone shared that with me. Did I ever verify it? No, but someone shared that with me, yes.
And the facts and circumstances relating to a suit like that, those would be facts and circumstances that you might like to know when offering opinions about someone's employment claims.
No,
None.
no.
Did you ever come to learn, Mr. Bright, that the court, in the case that Mr. Preston actually filed against Ms. Wilson and Mr. Walter, actually issued a preliminary injunction against them?
Someone told me that, but I don't specifically remember digging into that. Someone may have told me that. I may have looked at something that said that, but that's not something that's in my memory today.
And would it be an important fact if Anderson County took the position that Mr. Walter, for example, was acting in his official capacity when found to have been interfering with Mr. Preston's contract?
I wasn't asked to evaluate whether anybody was interfering with Mr. Preston's contract. I was asked, here's a demand from his lawyer that says he wants to leave and he wants this money. Will you please evaluate that for us and give us your best advice? And that's what I did. I wasn't asked to look into the background of Mr. Preston. I wasn't asked to look into any allegations that anybody was making about Mr. Preston. That wasn't what I was asked to do.
On October 23rd of 2008, you received a letter from Rob Hoskins.
I'm sure that's the right date.
And that letter stated in it that Mr. Preston's claims exceeded the four corners of his master employment agreement.
I went over it a few moments ago, and I read different parts of it. My position was he was making claims that went beyond just a contract claim. That he specifically was identifying tort claims against individual council members. And again, whether it was in my conversations with Rob Hoskins, he was reflecting wrongful discharge and any number of other types of claims. Yes, I thought it was more than a contract claim that he was articulating.
You thought it was more than a contract claim also because the October 23rd, 2008 correspondence says that his claims do in fact exceed the four corners of the contract, does it not?
Again, I think that's what I said earlier, and I think I referred to the second paragraph in the letter, and the second page of the letter, several paragraphs in there.
And those claims included tort claims, did they not?
Yes, specifically. I never knew the content of what those tort claims were, but they were, the way the letter put it was tort claims against several of the council members and newly elected council.
When providing advice about potential liability with respect to Mr. Preston's claims, did you ever study and research the Tort Claims Act?
I've studied the Tort Claims Act on many occasions.
And what does the Tort Claims Act say when there's instances where an individual is named, a government individual is named in their personal capacity?
Be more specific. What are you looking for?
The truth.
Do you suggest that I would offer anything else than that?
No.
I would be highly offended that somebody that I practice law with would say that. But go ahead.
Mr. Bryan, it was a joke.
And I didn't find it very funny.
Well, let's move on. Does the Tort Claims Act not, in fact, require the substitution of the government entity when individuals are